This is the second part of Wednesday's lecture, or Wednesday's lecture on the Judiciary. And in the notes, it's covered begins on page 3 from what I passed out in class yesterday. So we'll begin with Marbury v. Madison, one of the most important court cases in the nation's history, as this is the first court case in 1803 that the court self-consciously implied the power and used the power of judicial review to declare an act of Congress unconstitutional. So there's a good discussion of this case in chapter 12, and what I want to do is walk through the background and the events, the parties, and then the main legal questions, and look at Marshall's argument for judicial review. So the parties were, this is an extremely political case involving the judiciary, not the first time in our politics. And the political background is that in the election of 1800, the Federalists, who had dominated all the national offices and many of the state offices in American politics in the first decade of our political existence, were swept out of office. It was a landslide for the Republican Democratic ticket under Thomas Jefferson and Aaron Burr. And so, remember that at that time, the holders of national office began their terms in March because of the opening date of the first Congress on March 4th, 1789. So, in late February, John Adams, who was the outgoing Federalist president, coordinated with the Federalist Congress, which was still in office until that March, and constructed a series of about 44 judicial appointments because they wanted to keep the influence of the Federalist Party and get them in under the wire before the Republicans came in office in March. So in the haste of the last months and weeks of office, these appointments were ratified by the Federalist Senate, and their appointments were commissioned following Article 2, Section 3, that the President shall commission all officers, and their commissions were signed and sealed, and all but 4 of them made it to their intended targets, the intended appointees. So William Marbury was appointed for a federal judgeship in the D.C. area, and 4 of the commissions lay undelivered on, guess who was the Secretary of State under John Adams? John Marshall. Adams also appointed John Marshall to be the Chief Justice of the Supreme Court. So it was that last little bit of unfinished business of delivering the 4 commissions that left the judgeships in doubt. So when Jefferson came into office, he appointed James Madison as the Secretary of State, and Madison walks into his shiny new Secretary of State office and discovers the 4 undelivered commissions from the Adams administration. So he brings them to Jefferson and says, "What should you do?" And Jefferson says, "File them in the circular waste can." So William Marbury knows of his impending appointment, so he sues the United States, the Secretary of State, in fact, and initiates this court case as Marbury v. Madison. All Supreme Court cases begin with the plaintiff bringing the charge. So it's William Marbury v. Madison. It's William Marbury versus James Madison, the Secretary of State. And here's that. We'll walk through the legal questions. There are 3 stated ones, and there's an important 4th, decisive and dispositive question that is actually the thrust of the case. So we'll go over the 4 questions, the 3.5 questions, and it's important to see the constitutional issue shaping up. The President appoints the members of the Judiciary in the Supreme Court, for that matter, and so on one level, the question is, when is that appointment complete? Not when the President makes the nomination, of course, not when the Senate ratifies it. And we'll see Marshall answers this question. It's when the commission is signed and sealed with the seal of the United States that it becomes official. Then it's just undelivered. It's like the postman delivering letters at your house. So on one level, what had happened? Jefferson, the new president, in effect, canceled or annulled the last the appointments of the Adams administration that had not been delivered. So on one level, this is a question of presidential power. The president appoints, and can't the president unappoint? I mean, if the commission wasn't actually put in Marbury's hands, then does it actually belong to him? And was this simple an act of presidential discretion? As you're going to see, Marshall, who is brilliant, did kind of judicial judo here. He avoided a clash with the president because, as we'll see, when we work through the legal questions, if he decided that Marbury had a right to the commission, and that there was an official failing in not delivering it to him, the solution is, and I'll explain the main writ at the heart of the case, a writ of mandamus. A writ of mandamus is when a judge issues a writ to a public official to perform your duty. Mandamus means, like mandate, it comes from the Latin word command. So a writ of mandamus means we order that such and such be done. So the solution to Marbury's problem would be the Supreme Court ordering a writ of mandamus to the Secretary of State, who would then deliver the commissions. Now, of course, it's also aware that even though it's Marbury v. Madison, everyone knows this is Marbury versus Jefferson. So is President Jefferson entitled, as the incoming president, to appoint somebody else to that slot that Adams and the Federalist Congress had appointed? So, so in a way, Marshall, who was still in the early years of, this is 1803, of establishing the authority of the new judicial system in court under, remember, the Constitution is only about 13 years old, and the Supreme Court has had important cases, but it hasn't yet acquired the stature of the third branch of government that it does in our political system. So, so Marshall lays out the issues in front of him, and he asks three legal questions, and that's the way a Supreme Court opinion generally works. The person writing the opinion stipulates the main questions of law that the court has to interpret in order to come to the decision regarding the parties in the case. So Marshall lays out the issues. First, does Marbury have a right to the commission? And Marshall's answer to that is yes. He was duly nominated, ratified, and the appointment was commissioned and sealed. And according to Marshall's interpretation, at that point, once it's sealed, then the commission belongs to Marbury. It's his legal property. And therefore, that leads to the second question. Because in our court system and judicial system, generally speaking, the task of a court, either in a criminal or civil trial, is to ascertain what if there's an injury which the law can take awareness of, then the purpose of the court not only to identify the injury, but then also to impose or create a judicially manageable remedy. So a remedy to solve the problem. So if the first legal question is answered in the yes, that Marbury has a right to the commission, then the second question is there a legal remedy for his injury? And Marshall's answer is yes. It's a writ of mandamus, a judicial order to a public official to perform their specified duty. Now, a writ of mandamus, like other judicial writs, like a writ of warrant, a writ of injunction, all these, a writ of habeas corpus, these are all writs from the English common law. And in some ways, Marshall is simply asking this question, this is a court of law. Does this court have the power to provide a remedy to Marbury's injury? And as you're going to see, his authority for saying, yes, there's a legal remedy is, he turns the question then specifically, not can any court issue a writ of mandamus, but can the Supreme Court issue a writ of mandamus? And you'll see that's where the legal argument comes in. So the third question is, can the Supreme Court issue a writ of mandamus to the Secretary of State? And Marshall's answer to that is no. Why? Because the legal power to issue this writ was granted by a law of Congress, the Judiciary Act of 1789. Remember, the first Congress had to do several things like setting up the national government, the executive branch. It passed the Bill of Rights for ratification to the states, but also one of its major tasks in 1789 was setting up the federal judiciary, and it does that by an organic act called the Judiciary Act of 1789. And in Section 13 of that law, it says, it grants to the Congress, Congress grants to the Supreme Court the power to issue writs of mandamus in a certain series of cases. Now, Marshall, as we'll see, is going to hold that grant of authority to the court is unconstitutional, that in granting the Supreme Court the power to issue writ of mandamus to an official of the United States, that Congress exceeded the grant of a judicial authority to the Supreme Court. And what I want to do is you have to presume that Marshall knew what he was doing and that he could read the Constitution and that he understood the issues he raised. And yet, in the case itself, he speaks about the conflict between the congressional statute and the Constitution. And so what I want to do is make sure you understand what he's claiming why the law exceeds the proper grant of authority. Now, the background for this is that Congress creates the courts. In Article 3 in the Constitution, it says that the judicial power shall be vested in one Supreme Court and such inferior courts as Congress shall from time to time establish. And then, if you remember, when we considered the Constitution, Article 3 goes on and defines several kinds of jurisdiction, federal jurisdiction, and then it enters in Article 3, Section 2, this interesting distinction between, for the Supreme Court, original jurisdiction and appellate jurisdiction. And Article 3 says that the Supreme Court can have original jurisdiction. That means a case can originate on the Supreme Court. Typically, when a case comes to the Supreme Court, it's originated in a lower court, in a district court or a state court, etc., and it's moved its way through appeals up to the Supreme Court. So the question is, Article 3 says that in 4 specific cases, the court can hear an original case. The case can originate in the Supreme Court. The court has original jurisdiction. And those are in cases with the United States as a party, with an ambassador, a public minister, or a consul. The latter 3 categories, ambassador, public minister, consul, are all officials of a foreign state representing their country in the United States. So it's clear there's a kind of a principle here that cases that involve a question with one of the United States or the United States, or involving a foreign country, can go right to the Supreme Court as the chief court of the country. So how did, in doing this, and then the Constitution says the Congress shall specify all other kinds of appellate jurisdiction in which cases and how come up to the court. So how did the Congress violate the Constitution in granting this power to the Supreme Court? I'll read you from the text of Section 13, and here it is. It's on the bottom of page 3 of the notes and at the top of page 4. And be it further enacted that the Supreme Court shall have exclusive jurisdiction of all controversies of a civil nature, where a state is a party, except between a state and its citizens, in which case the state courts would be the case of origin for a case like that, between a state and citizens of other states, in which latter case it shall have original but not exclusive jurisdiction. Now, what the Congress seems to be doing here is refining the 4 cases of original jurisdiction by creating a distinction between original and exclusive jurisdiction. That's not the problem, as you'll see. And shall have exclusively all such jurisdiction of suits or proceedings against ambassadors or other public ministers or their domestics or domestic servants as a court of law can have or exercise consistently with the law of nations. And original but not exclusive of all suits, jurisdiction of all suits, brought by ambassadors, public ministers, in which a consul, vice consul shall be a party. And the trial of all issues, in fact, in the Supreme Court, and all actions of law against citizens of the United States shall be by jury. Now, I've italicized the part that Marshall thinks has violated the Constitution, and the rest of that paragraph on the top of page 4 of the notes. The Supreme Court shall also have appellate jurisdiction from the circuit courts and courts of the several states in the cases herein after specially provided for. Now, again, it's clear the law is talking about appellate jurisdiction, and so the law goes on. And shall have power to issue writs of prohibition. That's like a contemporary writ of injunction where the court issues an order not to do something, writs of prohibition to the district courts when proceeding as courts of admiralty and maritime jurisdiction, and writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. Now, what this means is when the court takes a case from a lower court, either from a lower federal court or a state court, it can, when it makes its decision, it can issue orders to it can remedy the cases or solve the case coming up to it in two ways. A writ of prohibition or a writ of mandamus can either be issued to the lower court to retry or rehear the matter consistent with the court's instructions, in which case the writ of prohibition or the writ of injunction would be issued to a lower court as part of the court's appellate jurisdiction. But then also it's typical in federal cases where the two parties are, one is the United States, or an official of the United States, works its way up to the Supreme Court, in which case, rather than have to have the lower courts retry the case or rehear it as a judicial process, the court may sometimes issue an order directly to the parties involved rather than retrying the whole thing. So that's how Marbury conceived of this issue and this case based on the language of the statute. Section 13 says that the Supreme Court may issue writs of mandamus and prohibition to any of the parties mentioned in the original and exclusive jurisdiction and to an official of the United States. Now, if you look at the Constitution, so let's see what Marshall sees the class here. So here's Article 3. One Supreme Court justice said, if you want to see what the court does, we just take a statute, lay it up against the Constitution, and see if it fits. Well, where's the conflict between what Congress did in the law and with Article 3 of the Constitution? And here it is. It's in the middle of page 4, also italicized by me. Here's Article 3, Section 2, Clause 2 of the Constitution. Clause 2. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, and with such exceptions and under such regulations as Congress shall make. So where's the conflict? How do they conflict? Here's what Marshall sees. Article 3, Section 2, Clause 2 lists, it's an enumeration, the cases and parties under which the Supreme Court has original jurisdiction, where a case may originate in the Supreme Court. All other cases have to begin in a lower court and be appealed up to the Supreme Court. So according to Marshall, and you know this from McCulloch v. Maryland, where he interprets the enumeration of Congress's powers. According to Marshall, all enumerations, all lists are exclusive. It lists something and then excludes other things by definition. So according to Marshall, Article 3 says Congress can only have these 4 cases of original jurisdiction. The Congress can't add an additional case of jurisdiction. And in authorizing the Supreme Court to issue a writ of mandamus to a U.S. public official, that the Congress in effect added a 4th category of original cases to the Supreme Court's docket, and therefore violated the Constitution. So, in effect, the constitutional reasoning is Section 13 unconstitutionally adds a area of jurisdiction to the original jurisdiction of the court. Now, do you see what Marshall has done here? He knew that if he issued a writ of mandamus to Secretary of State Madison, that Jefferson would certainly tell Madison to disobey the court. And it's not clear in this case whether or not the president has the authority to do such a thing. Nevertheless, Marshall knew that if he issued a court order to the president to do something, that he would probably lose that contest. So, as I said earlier, he performs judicial judo in a way. He, in order to avoid the conflict with the president, he turns to the statute by Congress authorizing the court to issue such a remedy. And now, of course, we'll work through his 4th legal question, which is, can the court can this court declare a law of Congress unconstitutional? So, but understand what he's done. By declaring the statute unconstitutional, he says, in effect, this court can't help you, Mr. Marbury. I can't issue the writ that legal justice requires. So, in some way, as the larger context of the case is, he avoided the conflict with one branch of the federal government, the president, and instead established the far more important power in some ways of the Supreme Court to declare laws of Congress unconstitutional. So, as I said, he lists 3 questions, but there's really a 4th question, which is the whole core of the case, and which he is in some ways unarticulated. And that is, since the court has just declared a law of Congress unconstitutional, can it do that? Does the Supreme Court have the power of judicial review to declare acts of Congress, but the president too, for that matter, unconstitutional? And here's the theoretical outline of his argument. Because Marshall typically, when he writes an important Supreme Court opinion, Marshall will state the theory and structure of the case based on the language and interpretation of the Constitution. Then he will turn to the text of the Constitution and will walk through his argument, which then supports his theoretical case. So it turns out that the question of can the Supreme Court declare a law of Congress unconstitutional can be divided into 2 subsidiary questions. A, Theory 1, you have to answer the question, can a law of Congress be unconstitutional? As you're going to see when we look at Jefferson's response to Marbury v. Madison, in a way, his view is that a law of Congress can't be unconstitutional. We'll explore that. And Marshall's answer to that is there has to be such a thing as an unconstitutional law, because unlike the British Constitution, where regular acts of Parliament actually change the unwritten Constitution, we have a written Constitution which is deemed to be fundamental and a limit on all subsequent governmental power. Therefore, if Congress's powers are to be part of a scheme of limited government under the Constitution, there have to be limits to its legislative authority. A Congress can't shape its own constitutional power. The Constitution grants and shapes it, and therefore acts of legislation have to be consistent with the Constitution's grant of legislative authority. The second part of that theory is, so if in theory and in principle a law of Congress can be unconstitutional, then Marshall turns to the B part of the theory, which is, can the Supreme Court make this determination? Can the Supreme Court, in a case before it, declare a law of Congress unconstitutional? And Marshall's answer to that is also yes. First of all, he says it's the very function of the judiciary. What is the task of the judicial branch of government? To say what the law is in specific cases. Now, the courts don't write the legislation. The legislative branch, Congress, writes the legislation. And as you well know from 8th grade, etc., the president enforces it. And then, if it leads to specific conflicts in cases, the courts, according to, and he's right about this, the function of the courts is to examine the conflict between the parties in the case under the interpretation of the law that guides it. So the very task of the judiciary is to say what the law means in specific cases. And as we saw in Hamilton's argument in Federal 78, here's Marshall turning to and adopted the core argument for judicial review that Hamilton makes in Federal 78. If 2 laws collide, if 2 laws are relevant to the case that the court's deciding, the judiciary is the one that has to decide what controls the case, what decides the case. And that means every time that the judges interpret a statute or a part of the Constitution and apply it to a case, they, of course, give meaning or interpretation to that statute. And so if the courts can't avoid interpreting the law and the cases in front of them, what happens when 2 laws apply to a case, as we saw with Hamilton, and one of the sources of authority is superior? And so, if in this case, if a law of Congress, whose grant of authority comes from the Constitution, and whose authority is therefore inferior to that of the Constitution, if the Constitution and a law of Congress both apply to a case and they conflict, then the court has to prefer the Constitution, and that is his decision. So, the answer to the question is not only can the Supreme Court declare a law of Congress unconstitutional, it can't avoid the issue. And so, like all of his great decisions, and this is what's the rest of page 5, Marshall then builds the case for his holding, his decision, out of the text of the Constitution. And so, in addition to this broad theoretical argument that we just saw, what's the actual language of the Constitution that supports not the individual decision that Article 3 was violated by the congressional statute, but what are the texts of the Constitution that support the idea that the court has this power to decide on the constitutionality of legislation? The first text is Article 3, Section 2. And even though I know you can read and I can read, I'm going to read it for you, and it's in the notes. Clause 1, the judicial power shall extend to all cases and law and equity arising under this Constitution, the laws of the United States, and the treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdictions, etc. So what that clause in the Constitution means is the judicial power, the power of the judges to decide cases by interpreting the law, shall extend to all cases which arise under this Constitution. And here's what Marshall means, and he's right about this. The Constitution therefore means that its own text can be used as a legal standard by judges interpreting cases. So the Constitution is a source of legal authority for the court. Article 6, the Supremacy Clause, which we're already familiar with. Clause 2, this Constitution and all the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound by anything thereby, anything in the constitutional law of any state to the contrary notwithstanding. So Marshall then says, okay, not only does the Constitution in Article 3 make the Constitution a relevant legal standard for judges, it says in Article 6 that in all cases where that happens, what's the supreme authority? The Constitution. And anything else, not only in the state law, but remember the clause says, this Constitution and all laws of the United States in pursuance thereof, and treaties of the United States shall be the supreme law of the land. So Marshall, in effect, creates a hierarchy of authority. The Constitution, U.S. law, U.S. treaty, and then state law. And he's right. That's the proper interpretation of Article 6. But here's what he says is that means that what's superior to a federal law, a law of Congress? The Constitution. And then the third text is also in Article 6, the oath of office. Clause 3, the senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. So the third text is the oath of office, and by that Marshall concludes that judges of this court, now everybody in the federal and the state governments has to take an oath to support the Constitution. That's not unique to the judicial office. But Marshall is saying here that judges have, including the Supreme Court justices, have to take an oath to support the Constitution. Therefore, if a law of Congress conflicts with the Constitution, Marshall concludes that their oath of office requires them to disregard the law of Congress and prefer the Constitution. So, in sum, what is judicial review here? Strictly speaking, it is the power of the court over its own standards in cases. That is to say, to define the laws that are relevant and interpret them to the cases they interpret. A way of maintaining its own constitutional independence, as Hamilton had sort of outlined it in Federalist 78. Judicial review would appear to be the power to ignore as a legal standard for a certain law for the resolution of cases, an unconstitutional law. So that's the classic case for judicial review. And the country has accepted it, not universally, as we're going to see. But again, as I said in class, the question before the court today and the courts is not whether it has this power. Hamilton interpreted it such in Federalist 78, and Marshall authoritatively, as an act of the court, supported that power in 1803 in Marbury. And again, since that time, it's been the general consensus of our legal system and our political system that the court has this power. But as we'll see, the question today is how does it use that power and how does it interpret the Constitution? So Jefferson was not happy with Marshall. He knew that Marshall had avoided a conflict with him, which he would have lost, Marshall that is, and he never accepted the position that judicial review, this power of the court was a legitimate constitutional power. Now, by the way, it's not a stupid argument, as we'll see. Part of it depends upon what we saw in class. We know the president has the power to veto a law because it says so in the Constitution. And therefore, in a way, Jefferson's argument, his broad unsuitability of judicial review, is if the judiciary, the third branch of government, was to use this kind of power, which is really, when you think about it, it's a remarkable power given in another branch of government, that power to reject the law would have to be explicit in the Constitution, like the veto power. But at any rate, the country since then has accepted Marshall's argument, and the court has this power. What was Jefferson's argument that this power is unconstitutional? Well, Jefferson gives a no answer to the question whether the court should have this power or the federal court should have this power. Why? His first argument is that the Supreme Court does not have the constitutional authority to judge the constitutionality of the president or the Congress. And his first answer is, in our constitutional system of separate but equal branches of government, where one branch has the same amount of constitutional power as another, that it would be inconsistent with that constitutional design to give one branch the power to determine the constitutionality of the acts of the others. Well, what's the alternative? Jefferson says, in our system of government of separation of powers, each branch has to decide its own constitutionality. Now, what that would seem to suggest then is that only the Congress can decide if its laws are constitutional, only the president can decide if his actions are constitutional, and only the Supreme Court can decide its own legal cases. So on one level, Jefferson's simple argument is judicial review makes the judicial branch the supreme branch of government, which is inconsistent with the constitutional design. Now, his backup option, his plan B, is if one branch should have the power to determine constitutionality for the other branches, then it should be Congress. Why? Because this is a democratic republic. Congress is elected by the people and has popular responsibility. And otherwise, to give this power to the court would be to give a form of institutional supremacy to the judiciary, which the Constitution doesn't warrant. And so in some ways, Jefferson's arguments against the court exercising this power, even though Marshall's arguments and Hamilton's arguments kind of won the day and have established the precedent for our courts and judicial system, there is a certain sense in which Jefferson's reservations echo through the different interpretations of judicial review that were examined. Because it's an awareness that if the court does exercise a power like this, it's the only unelected branch in the government that has no popular responsibility. It's not elected, and it serves for life. So Jefferson's reservations, although they didn't persuade anybody, nevertheless kind of highlight the fact that we are all aware that if the court does have this power, it's a very delicate power of popular versus constitutional authority. So in the rest of this lecture, like all the other institutions that we've examined before, we've looked at the original design and purposes and controversies. Then we are going to look at the historical development of the institution. And then the last part will examine the controversies in that institution. In this case, how judicial review should be used and employed when it interprets the Constitution. So just a couple of general concepts. If you're looking at the notes on page 6, this is from chapter 12 of the Wilson text, in which he outlines the different processes and structures of the federal judiciary. And so, as I said in class, the judicial branch of government essentially derives from the British model of the judiciary. Our judicial system is essentially a British system. There are two basic kinds of legal systems in the world. The kind of continental European system, kind of based on Roman law, and then the British Anglo system, which is based upon the evolution of English common law. Now, we won't go fully into the meaning of the common law, but that's a term that came to describe English judicial practices and structure in law that dates back to 1170, when Henry II established the common courts of England under his authority. And then that's where the hierarchical structure of a basic district local level with an intermediate appeal level and then a highest authority on the top of the pyramid. And so basically we follow that. That's why our federal judiciary is hierarchical, and all the state judiciaries essentially follow the same model too. So also the structure of the federal judiciary derives from actual grants of authority in the Constitution in Articles 3 and 6. Because the Congress creates the courts, they outline their procedures and their jurisdiction, and determine salaries and everything else. Now, the one constitutional limitation on the Congress's power to set salaries, which makes it different from the president, is the Congress cannot raise or lower a president's salary during his term. And for the judicial offices in Article 3, the salaries of the judges cannot be lowered; they can be raised. And if you think about it, that's a necessary concomitant of good behavior of lifelong service, because, of course, as we're seeing, inflation can change the value of money. So we have to be able to raise court salary, but not lower them as a threat. So, and so on pages 249, etc., Wilson then lays out the structure of the federal judiciary, with the lowest level of about 95 or 96 district courts, essentially 2 for each state, although some states have more federal courts in them, like California, obviously, than other states. So you have the lowest level of district or lower courts, and then beneath that, of course, you have the state courts, which raises certain specific questions. But then you have the lowest level of federal courts, and then the 13th Circuit courts, or appellate courts, because remember, originally the members of the Supreme Court who were on the court actually rode circuit, as it was called, and presided over the appellate courts, and that's why they're called circuit or appellate courts. And then, of course, the highest level of authority is the Supreme Court. So basically, as Wilson points out, most of our state courts follow the same model of executive appointment, senatorial ratification, and lifelong service. But at the time of the progressives, around the turn of the century, many states experimented. There's no state that elects its judicial officials, but many states modify the federal model by having the original appointment of court members by the executive, the governor, or and the Senate, but then having with a limited term and re-election afterwards. So about, I think 15 states have some modification that way. But mostly our system follows the British system, as I said. Here are a couple of specific issues which he discusses, and which have become controversial since the 2020 election, and since it became clear that President Trump, that his judges would constitute a kind of a governing conservative majority on the court. There have been issues of the court's membership, its size, and of course here's the point. Article 3 doesn't actually say how many justices shall be on the Supreme Court. Originally there were 7, and then expanded to 9 during the Civil War, and then 11, and by custom it remains at 9. So on one level, the idea of expanding the size of the court and limiting its terms with a set term, that's been an issue as long as the court has exercised this power of judicial review. And in 1937, frustrated with the Supreme Court's declaring major portions of his New Deal legislation unconstitutional, FDR actually proposed expanding the size of the court to 15 with terms of retirement, so he could actually control the content of the court's interpretation of the New Deal. That, even though Roosevelt was a remarkably popular president, that single idea resonated badly, and the critical response was such that Roosevelt dropped it. Well, that's become an issue again, because it looks as if, and in fact this is exactly what's happened in the case of Roe v. Wade, it looks as if there's a majority formed to make a major pronouncement on that. So on one level, some Democrats in the Senate have suggested expanding the size and therefore some what's called packing the court to produce a particular response. So, but I have to say those are still controversial enough to have beat back the attempts to do that. Even as intense and popular as the reaction to the court's action in Roe v. Wade will be, nevertheless, there hasn't been enough of a political will to tamper with the essential structure and place of the court. So in Roman numeral 2 on page 6, Wilson goes through several important concepts that that describe how our judicial system works in certain issues. One is jurisdiction, and we've already seen from the Constitution that there can be you can define a court's jurisdiction, which is the legal right to offer a decision in a case. You can define it by geography, that is to say where the case originates, by party, who's a party to the case, whether it's a foreign country or the state of the United States or the citizen of one state, or the issue. And to some degree, like when it comes to civil suits, there's a monetary distinction. I think it's $25,000 now, where a case can get into the federal courts if it has a certain dollar size or issue. So the second important, when we discuss this in class, is stare decisis, which is Latin for let the decision stand. And that's the doctrine of precedent in our courts, which we discussed. Remember, in the British system, the precedent a court establishes binds subsequent courts absolutely. They can reinterpret it, but they have to consider it a standard. So in our system, remember, precedent cases guide the court, but do not bind it. So the Supreme Court is free, although it obviously reserves this power to special occasions because it wants to preserve the stability of the federal body of judicial decisions and judge-made law. So, but nevertheless, the court will and can overturn one of its own precedents. An important concept that Wilson discusses, and this is central to the outcome of many cases, aside from the issues in the case, is standing. Standing is the legal concept that the parties that bring a case to a court, into the Supreme Court, must be, they must have sufficient issue in the case, stake in the case, that justifies them raising a case. So in some ways, the doctrine of standing says, if a person is not personally damaged or supported by the outcome of a case, if a person has no practical interest in a case, then he can't be a party to a case before the Supreme Court. Because Article 3 says, the judicial power shall extend to all cases and controversies arising under this Constitution. And the court has interpreted that meaning that if you bring a case to the Supreme Court as a party, you have to have a stake in the outcome of it, a substantial one. Otherwise, there's no case because there's no conflict or real conflict of interest between people. That's still an important concept in our law. And in fact, you could say that in some of the cases regarding the controversies in the 2020 election, some of the cases that were rejected by advocates of President Trump were not because of the issues of the integrity of the vote, but whether or not the parties bringing the suits are actually legally justified to bring this suit. So this is still a very powerful concept in our law. The Wilson text describes several law writs that determine how cases get up to the Supreme Court. Now, there's a whole system of defined appeals that Congress sets up. And in the late 1880s, it kind of concretized the power of the court to hear its own cases on appeal in what's called a writ of certiorari, which is a writ of let it be certified. So the way that most of the cases get to the Supreme Court, and the Supreme Court had a kind of a peak of a judicial workload in the 80s and 90s, where it probably heard between 300 and 350 cases a year, which was a lot. So the court has kind of tried to get that down by managing its own caseload more effectively. And so writ of certiorari works when an issue comes before the court and at least 4 of the judges want to certify this as a case, it can proceed. Today, the court hears about 150 major constitutional and federal law cases a year, which is about as much workload as it can manage intelligibly. So most cases get up to the court when 4 members of the court issue a writ of certiorari to hear the case. There are other forms like informa pauperis, a poor person can plead, and actually that led to an important Supreme Court decision in the 1960s, Gideon v. Wainwright, where a guy had been framed in Florida law and was serving a jail sentence, and he wrote in pencil on paper from prison. And the case was appealed to the Supreme Court, and indeed, the important outcome was that people have to have legal representation in all criminal cases before the federal judiciary. So we discussed in class the kinds of opinions that the court can issue, that members of the court can issue. They can issue a per curiam, which is Latin for the court. That's where the court issues an opinion for the whole court it has to be unanimous, and where it's not in the name of any one justice, but the court's writing for itself. The other three kinds of opinions, again, are majority, when a justice supports both the decision and the outcome of the case, and the legal reasoning for that outcome that the majority attach to it. It can write a concurrence in which it agrees with the opinion, the decision, but not the opinion, and therefore wants to justify the opinion in another way. And then it can issue a dissent, in which case it disagrees. The member of the court disagrees with both the outcome and the legal opinion. The last major question that Wilson deals with is the growing propensity of class action suits, where the people represented as a party aren't just single parties, like Marbury in Marbury v. Madison, but where the plaintiff represents a whole class of citizens, a class of complainants. And the only issue there is the more class action cases the court decides, the more it comes to use its judicial power almost like a form of legislation that acts on entire classes of people. So with that, we'll conclude with the current controversies on the court. And that is, as I mentioned several times, it's not whether the court has judicial review. It's how it uses that power, which means it becomes a question of how the court interprets the Constitution, especially when it's going to hold the Congress, the President, and the other political entities, such as the states, subject to its decision. So this has raised the issue of judicial ideology or philosophies. That is to say, how a judge interprets the Constitution. And that kind of explains the partisan balance on the court today. Prior to the 1980s, pretty much a president could be guaranteed that his judicial or her judicial opinions would be accepted by the Congress, because the main question that the Senate raised in ratifying judicial appointments was the person qualified. And that meant basic qualifications such as legal expertise, not being drunk or crazy, but it didn't extend the question of how the judges interpreted the Constitution. But since the 1980s, that question has moved front and center. And it used to not be a partisan divide between Democrats and Republicans. So what's that partisan divide, or what's the theological divide? One way of describing one orientation on the court is what's called activist and restraint. And Wilson discusses this. In this dispensation, the judges are obligated to use the power of judicial review actively to shape the nation and to shape the judicial and legal system and the rights of Americans. And in doing so, they are simply enforcing their vision of the Constitution. The opposite of that is restraintist. It comes from the idea that even if the court legitimately exercises this great power of judicial review, it should do it in a restrained fashion, because it risks turning itself into a super legislature or a super judicial authority. So on one level, you could say that that the activist restraintist spectrum is a vision of how the courts function in the overall constitutional system is. And should the court generally defer on the constitutionality of the other branches, or should it actively seek to shape and overturn that? The other judicial difference of judicial philosophy that's come into being since the 1980s, and Justice Bork, as you'll see, is represented in this selection, and especially Justice Scalia, and probably the majority of the court today, is originalism versus what you could call the living constitutional theory. And that is how judges interpret the text of the Constitution. As we saw in class, the originalist theory holds that judges only have the authority to declare laws or actions of the other branches unconstitutional if those actions violate the original understanding of the Constitution when it was drafted and ratified and passed. So the living constitutions, so let's examine those two. Just 1 second. By the way, before we turn to the controversy over judicial philosophy, let me just lead you through one part of the text in chapter 12, in which Wilson describes the kind of historical stages. You can't quite call them stages, but there have been different periods where the court used its authority and the power of judicial review differently with different issues. And on page 7 of the notes, for instance, in the first part of its several decades, the court focused on the expansion of national authority and, of course, the issues of slavery, such as Dred Scott, that led up to the Civil War. And then after the Civil War, the growth of the economy, and then the court became much more interested in what was called economic jurisprudence. That is to say, keeping the commercial power of the United States limited under national authority, the Commerce Clause, and then limiting the power of the state's economic authority. And that orientation kind of went up right up to the New Deal. And indeed, the court's attempt to restrain the national government's power in commerce finally gave way in 1937 after the threat of court packing. And then since then, there have been two major issues that have really dominated the court, and that's the personal rights and political liberties. Since 1937 to the present, especially the Warren Court, which was in the 1950s and 60s and early 70s, focused on the definition and expansion of personal rights under the Bill of Rights and the 14th Amendment. And then there has been the ongoing issue of state sovereignty and the proper role and limits of states in our system. So let's finish with the conflict between Bork and Brennan, which is a controversy still alive on the court today. And here's the problem. The problem is the court has this power, judicial review, in a Republican or Democratic system. And so in some ways, both Bork and Brennan was a Supreme Court justice, I think the longest serving for 42 or 40 years, and Bork was a nominee to the court, but who was rejected by the Senate. So here's what they agree on. They agree that it's problematic and yet necessary in a system of separation of powers and checks and balances. They both agree that it's a function of the court to update the Constitution. And don't forget, there is a process of amendment by which the American people can update the Constitution. But here's where they differ then. For Brennan, the Supreme Court is not just the supreme judicial body of the United States. It's like the moral pilot of the United States, the moral pilot of the nation. Judges articulate the constitutional principle of equal human dignity and steer the nation both on the national and state level to a system that represents the dignity and or the rights of the individual. So what's important for Brennan in interpreting the Constitution, this is on the top of page 8. For Brennan, you can't follow the origin of the original intention of the founders of the founding generation, because we've evolved since then. For Brennan, the country's in a constant state of evolution, moral and political evolution, and the function of the court is to recognize how different the circumstances of government and life are today. And therefore, in interpreting the text of the Constitution, they use the 1789 text, but not with the 1789 intention or interpretation, and that's why this interpretation is called a living constitution theory. So when he says, and what's his criticism of those who just want to follow the original intention like Scalia or Bork? In a way, he calls it a vanity on their part, that they think they can know what the founders meant. And therefore, since they have to use their discretion anyway, they might as well import into the interpretation of the Constitution their grasp of contemporary reality and moral and political evolution. So why does Brennan think that the court must stand against majoritarianism, a blind faith in democracy? Even Hamilton says that. This is a democratic republic, but it's ultimately a system in which the rights of the individual are the primary function, going back to the Declaration. So on one level, everyone agrees that at times the court has to stand as a non-elected, non-majoritarian body, standing for constitutional values, even when there's intense public pressure for or against it, the independence of the courts that we talked about. So, nevertheless, for Brennan, the task of conscience and getting the rights of the individual and the vision of the nation properly means that the court should much more aggressively, actively confront the other branches of government and use its authority actively to shape the living constitution in the nation that it presides over. For Bork, the Supreme Court is its primary function in exercising judicial review is a constitutional check on inappropriate policy and inappropriate majoritarianism. Judges do not make law, according to Bork. They find law. The court's job is not to steer the nation, but to restrain it when it departs from the Constitution. So remember, this question depends upon where the judge's authority derives from. And for Bork, the question is, why is the intention of the framers the most important guide for Bork? First of all, he thinks the intention, not that he's a mind reader or that he knows better than anyone else, although supposedly scholarship and study of the founding should grant you some grasp of it. For him, it's not a question of the judges presuming to know what was in the mind of the framers. You can read the text of the Constitution, you can study the history of the times, but rather his argument is the function of the judges is to maintain that Constitution in place until the political branches change the Constitution through amendment, which is the only genuine way to update the Constitution, according to Bork. So on one level, his philosophy of judging is the court has to be able to find a discernible constitutional issue in the text of the Constitution, and therefore use the power of judicial review in a restrained fashion. So I have questions for both of these guys. One way or the other, judges have to give meaning to the Constitution, and obviously the kind of cartoon version of this conflict is, on the one hand, you have Brennan saying the courts are the conscience of the nation, and therefore we have to judge what the nation means. Well, that's a lot. I mean, they're more than the Supreme Court in the nation. So on one level, who gives Brennan the right to intuit where the country is? Shouldn't the people decide that in laws and in public opinion and in constitutional amendments? So in some ways, Bork's argument would be, to Brennan, how can you read the minds and the soul of the American people? Why is that more or less pretentious than presuming to understand what the original meaning of the Constitution was? So, and by the way, you could say Bork may have caught Brennan in a contradiction, because while Brennan says that judges can't be mind readers and know the minds of the generation of the founders, but then it turns out Brennan turns around and states what the intentions of the framers were. So all participants in this discussion believe, on one level, the intentions of the framers are somewhat accessible to contemporaries. So the last thing I want to say on this question then is, that's the main division, and to some degree that's become a partisan issue between Democrats and Republicans. Not simply, but largely. And so I just want to end with the same question and the same set of principles that we ended the presidency with. On this question of how to interpret the Constitution for the judges and what their authority is in the constitutional system, you'd have to say that, just like the other branches of government, there are constitutional and systemic restraints on judicial power. Congress can shape the judges' authority to some degrees by legislation, by presidential appointments, as we saw with President Trump and with President Biden and his appointment of Ketanji Brown Jackson. And then also, Supreme Court decisions and power can be limited by constitutional amendment, as we've seen. Remember, Dred Scott in 1857 was overturned by the 14th Amendment. So constitutional amendment can limit the effect and authority of the court's power and jurisdiction in the system. And just for your information, the original income tax law was declared unconstitutional by the court in 1896, but then the 16th Amendment overturned that and made the income tax constitutional, and there you have it. So on one level, the court, like any of the other branches of government, the Madisonian system is still, I think, vibrant and strong. The Constitution is the supreme authority of the country, depending, of course, how it's interpreted, and in some ways, it still does what the framers intended the system to do. It grants the powers of government to the three branches of government and the states. It puts significant limitations on that power, because ultimately the real task of the Constitution points back to the Declaration, which is to secure rights. And therefore, the constitutional republic and the separation of powers and checks and balances are the framers' main choice to set in motion a nation that achieves not only prosperity, but also the rule of law and political and individual freedom for the foreseeable generations. And that's our class.